Hi, this is a special presentation from Reddy Neumann PC. This is only for those people whose children are born outside the country and the children may become 21 before the parents get the green card. If any of your children would be becoming 21 before you get the green card and you are in a non-immigrant visa and your children are in a non-immigrant visa, you need to listen to this video. This is a general information video only. For any specific immigration questions, we recommend that you contact a competent immigration lawyer. This is for general information purposes only. Emily, we see a lot of people who are coming into the United States on a non-immigrant visa. Previously, things used to take only 3 years, 2 years. I mean, at the time when I got my green card, it was only 2 years, so we didn't used to see a lot of children who, growing up here, especially those who are born outside the country. Now it is becoming very common that the children are becoming 21 before the parents get the green card, and they will be kicked out of the application in most of the cases. Now, I want everybody to aware of what are the things that are there, what are the things the parents need to be aware of, what are the things that the children need to be aware of. First, I want to explain the process that in the green card process, when is it safe that the children are going to be safe? I mean, they will get the green card along with the parents. Can you first explain the Child Service Protective Act, which was passed to protect these kids?
Right. So the general rule is when you are applying for a green card for yourself in the employment-based category, your spouse and children can receive that green card along with you. But the immigration law defines child as someone who is under 21. So only those who are under 21 at the time your green card is ready to be approved can receive the green card with you as your child. That leads to some children, when they turn 21, they get kicked out of their parents' application and they become their own process. They start the whole thing all over again, just like you went through. So in 2002, Congress passed a law called the Child Status Protection Act, which was meant to kind of minimize the harm that this turning 21 would cause. The whole idea of it was to minimize the harm caused by delays in processing the I-140. It's not meant to minimize the harm due to delays from retrogression, when your priority date moves backwards, or now that you file under the filing date chart and your final action date might take 10 years or 5 years to become current. This law was not created at that time. The two charts weren't a thing, and so the Child Status Protection Act is now kind of morphing into a big monster that doesn't protect as many people as originally intended. But that's the goal, is to minimize the harm caused by delays in approving your I-140 petition so your child doesn't age out due to that kind of delay.
Two corrections, Emily. One of the things is that the child must be under 21 and also unmarried. The second thing, Emily, is that, of course, I've been a lawyer before this law came in. So before this law came in, the rule that the age will be deducted when the I-140 is pending was not existing. The other thing is that at that point of time, before this Child Service Protective Act didn't came in though, if the child ages out when the adjustment of status is pending, they will be kicked out of the application. So the Child Service Act actually came in to protect the age of the kids while they are in adjustment of status, and also while their age will be deducted from the period of time that the I-140 is pending, their age will be deducted. Now, I have a couple of questions on this, Emily. Everybody knows that the age of the kid will be deducted from the time period the I-140 application is pending, that time period. So, for example, if the kid is aging to be 21 year and 8 months, and the I-140 is pending for 1 year though, so the 1 year will be deducted from the age of the kid. Now, Emily, can you explain that when does the age freezes out, especially when they are in adjustment of status? When the CSPA law was passed, though, Emily, the age of the kid was frozen at the time when we filed the adjustment of status. Is it still the same?
No, it's not.
Why
that
did it
simple
change
anymore.
at that time when the law passed? It says that the age is freeze at the time of filing the adjustment of status.
Yeah, it's because of the two filing charts. So the final action date chart, that's when your green card is immediately available and you can receive the green card when your priority date is current under that chart. The filing date chart, a green card technically is not immediately available yet, but they think it might be, so they allow you to file early to take into account the amount of time it takes to process the 485. So these charts were created in 2015, whereas the Child Status Protection Act was in 2002. So it has changed how all of these calculations happen. So what we have to take into account is when the final action date actually becomes current, what is the child's actual age on the first day of that month? That's item number one you need to know. So you really can't make these calculations until your final action date is current.
Okay.
Which could be years from now. So
So
we're
it's
kind
not
of guessing.
it's not by filing the adjustment of status,
Exactly.
because filing dates are not the things, it's the final action dates. Now what if, Emily, if let's say for example the I-140 downgrade application is still pending and now we have the final action date becomes current, does that mean the child is protected and he can get the green card?
Not yet. That's the other factor we need to know is the I-140 approved? So a green card is, even if your final action date becomes current, a green card is still not immediately available for you if your I-140 is not yet approved. So we have to know when the final action date becomes current, your I-140 petition must be approved, and then we have to know how long the I-140 was pending and whether your 485 has been filed. Once we know all of those things, then we can actually calculate what the child's CSPA age is to determine if it's under 21 at the time the final action date becomes current. And if so, if you have a pending 485 at that point, the age is frozen and they're good. Even if your green card takes 10 more years to process, from that point, they're good. But if the child's age is over 21 at that point, they're out.
Emily, you said 3 times in the past 5 minutes that the age of the kid will be deducted for the period of time the I-140 application is pending. The age of the kid is deducted. You said that 3 times. What if I filed an EB2 I-140 and now I filed an I-140 under EB3? So I filed an adjustment of status. Does that mean that I count both the I-140 dates, or is it only one I-140 time period that is pending?
No, and this was actually recently clarified by USCIS. It is the I-140 that supports your 485. That's the only time period we're looking at. So if your old I-140 and EB2 took a year to process, that time doesn't matter. They're looking at your downgrade I-140 that you filed right now. That is what is supporting your 485. So it's that I-140 only that they will determine how much they can deduct from the child's age.
The age of the majority in most of the countries and some parts of the law says 18 years. You're keeping on telling it's 21 years. Which is age, though, for the purpose of the CSPAs?
Yeah, for the purpose of immigration, a person is considered a child until they turn 21, not 18. Normally, it's when you turn 18, you're an adult. Here, it's when you turn 21, you become an adult. Prior to that, you're still a child for immigration purposes.
In a simple language, Emily, you said that there is a CSPA age and a regular age. So let's say, can you differentiate between the regular age, that means the natural age, and CSPA age? How do you calculate that?
Yes. Okay, so again, we have to know what the child's actual age is on the first day of the month when your final action date becomes current. Mm-hmm. If that age is over 21, mm-hmm. that's when we have to make this calculation. If the kid's age is under 21 at that point and your I-140 is approved and you filed the 485, you're fine.
So let me understand. If the person has filed an adjustment of status and the I-140 has been approved, and the person is under 21 at the time of final action date is current, so he's protected, and even if it takes 10 years to get the green card, the child is protected. What if the priority date backtracks in that?
You're still fine.
So once at one point of time, at any point of time, the child should be under 21 And I-140 should be approved, and the final action date should be current, and they're protected.
Yep.
Okay.
All right. So now let's say at the time the final action date becomes current, the child is 21 and a half years old. Now we have to look at how long was the I-140 pending, the one that supported this 485. Let's say that you filed in a premium processing and it was only pending for 2 weeks. We deduct those 2 weeks from the child's age, they're still over 21, they're out.
Okay.
Let's say your I-140 was pending for 8 months. The child is 21 and a half months. So on that first day of the month where the final action date is current, the child's real age is 21 and a half months, but the I-140 was pending for 8 months, so their technically CSPA age is 20 and
10 months.
under 21.
20 and 10 months, yeah. Under 20.
So if your 485 is filed, then that child is protected going forward no matter how long it takes.
What I recommend everybody is that you need to have a calculator what a CSPA age is. You deduct the I-140 period of time pending that is there. You put it on the calendar. Since the final action date is not current, they keep on aging. Once they hit 21, you deduct the I-140 period. Once they hit 21, they are out of the application. So Emily, if somebody is going to age out, where we think so that they're going to age out, what is the precautionary things that they should be doing?
Yeah, the most important thing is to continue to maintain the non-immigrant status. You cannot rely on the adjustment of status. We've referred to that many times as marrying the adjustment of status. That goes for the child as well as the parent. You both have to maintain your non-immigrant status, your H1 and H4 or L1 and L2 status. And the reason for that is if the child ultimately does age out of the green card process, they still have the opportunity to change status to F1 because most likely when they're 21 years old, they're still studying in school. If they do not continue to maintain that underlying non-immigrant status, either the H4 or the L2, for example, and then they get kicked out of the adjustment of status, they then have no status. There's no way to go from no status to F1. There's no way to go from adjustment of status to F1. You have to be in a non-immigrant status the whole time. So if the parent who's on H-1B, for example, decides to use the EAD and work for another company, the child is no longer in H-4 status. If the parent travels on the advanced parole, now they're not in H-1B anymore. The child is no longer in H-4 status. So we don't want you to get married to your adjustment of status, and we want you, in most cases, to let your I-140 take as long as possible. Don't premium process the downgrade. Obviously talk to your attorney about this, but that would be one way to try to maximize the amount of time you have before your child actually turns 21.
Emily, you said the CSPA age of the person is different than the actual age. Now people know how to calculate the CSPA age. So next time when somebody asks, we will quiz them on the CSPA age. What is the kid's CSPA age? Now, having said that, is the CSPA age also, that means the deduction of the time period, is that also applicable for H4 or they get kicked out on H4 though?
Good question. Yeah, it is not applicable for H4. So this is only applicable to the employment-based green card process. When they turn 21 on H4, they're kicked out of H4 regardless of what their CSPA age is.
Uh-oh. So when you're advising the people that they may get kicked out of the adjustment of status though, because as the CSPA age becomes more than 21, they should apply because they should not look into CSPA age, they should look into the natural age to file for the H4. So can they apply from change of status when they're in adjustment of status from H4 to F1?
If they did not get married to the adjustment of status by using the EAD or advanced parole, or the parent using the EAD or advanced parole, yes, they can file a change of status from H4 or L2 to F1. Just be aware that that has to be filed before you turn 21, and the processing time is going to be an issue. If you want to explain a little bit about that.
We'll get into the processing time later on. So you should apply for the F1 before they turn the natural age 21, not the CSPA age 21. And also we strongly recommend that they file it well in advance, and I will describe you what is the processing time, what are the things that are available in there. A lot of people have asked questions when they are in adjustment of status. Can they file the F1 visa, F1 change of status, if they maintain the H4 or L2? We haven't seen much problems for the kids who have been filed in this one. We don't know how the things in the future will be, but at this point of time, we haven't seen many denials for the F1 visa for the people who are in adjustment of status. Emily, let's explain for the people who are in H4 or L2 visa and they are applying for the F1 visa. What are the things, how long is it taking though?
Yeah, it could be anywhere from 8 months to 23 months.
So let's say, for example, the kid is becoming 21 in 4 months. We file the F1 status right now. Can he stay legally in United States, or is there any other thing that they need to take care of?
Yeah, they're going to have to file another application, because the way the F1 works is if it's the application for the change of status is still pending at the time that you normally would start your classes, your school is automatically going to defer your start date to the next semester. Now, if that next semester starts after you've turned 21, now you have a gap from the end of your H4 or L2 status, which ends when you turn 21, to the beginning of the new program start date of your F1. You have to find a way to bridge that gap, and the most common method is what we call a B2 bridge application. So you're going to file your change of status to F1 before you turn 21. And then if the start date gets moved forward due to long processing times, before you turn 21 again, you have to file a change of status to B2. So you're going to go from H4 to B2 to F1. That's the goal. You may have to file 2 B2 applications.
Why can't I file for 1 year B2?
Yeah, because you can only request 6 months at a time, and your F1 may be taking longer than a year to process. So you have to watch those dates really carefully to make sure that you don't fall out of status during this process.
We strongly recommend that you start the process at more than 1 year before the kid becomes naturally 21. And absolute requirement is that you need to file the bridge application before the kid turns 21 when the F1 application is pending. If you don't turn in that B2 bridge application, the F1 will be denied. So please be very watchful. We also want people to understand that the priority date movements are we cannot predict it. I will tell you that it's very hard to predict it. So don't try to get married to the adjustment of status if your kid is turning 21, or I would say even if the kid is about, I don't know what age, I would say that if kid is 14 years, you should be very careful. That's my recommendation. It's not that I'm going to stick with this 14 years. I may change this one, but if a kid is 14 years, I'll be very watchful and trying to calculate the CSPA age and keep it updated every month to see when the final action date becomes current. Also, Emily has pointed out very good thing is that once the final action date becomes current for you, and I-140 is already approved and you are in adjustment of status, your child age is locked and then you don't have to worry about it. We only need that only one time. That's what Emily told. The I-140 must be approved, adjustment of status must be pending, the final action date has become current. Even if the later months, the final action dates go back, your child is saved. No matter whether it takes 10 years, the child is saved. The only condition that is attached to it, the child should not naturally marriage. Not adjustment of status marriage, not get married to another girl or boy, depends on. So that's the one that need to be avoided. But other than that, however long it takes, the child is safe.
We also want to discuss, other options to get to F1 status. We've talked about the typical process, which is a change of status from H4 or L2 with that B2 bridge. But what about applying at the consulate? Do you think that would work?
Especially if the kids have already applied for the adjustment of status, Emily, I will try to avoid the trip to the consulate though. Because in the consulate, they need to prove that in the US, they also need to prove whether they apply change of status here. There is a condition that they have to prove that after they complete their education, they're going to go back. Especially when they file a change of status, if by any chance they get an RFE, they can get a legal help, they can contact lawyers, and lawyers will be able to articulate it much better. But when they go to the consulate, though, to prove that after filing the adjustment of status, they are going to go back to their home country once they complete the education, which for these kids who have did high school, it's very tough. What is their home country? It's very tough to explain. I recently had a couple of appointments, Emily, and the kids started crying. I mean, I don't know what to do. I'm not trained for it. So these kids, when they go to the consulate, they may not able to articulate the issues much better. And if their F1 gets rejected, they may be in great trouble because they're out of this application, their F1 gets in trouble. So it would be advisable to apply for change of status while they're in United States so that they can get any legal help when the RFE comes in.
All right, so just to recap, we have to know what the child's actual age is on the first day of the month when the final action date becomes current. We have to know how long the I-140 was pending. The I-140 has to be approved, and the adjustment of status has to be filed. If at that point the child's CSPA age, when you subtract the amount of time the I-140 is pending from the child's real age, if it's under 21, the child is good to go. If it's over 21, they're going to be out of this application and need to be prepared to file the change of status to F1.
So also, if the I-140 is pending, that means that the age of the kid is not growing. So please make a note on that thing. I would like to keep a CSPA calculator in there with you at all point of time so that you can understand much better what's going on and take the decisions accordingly. The time period of I-140 will be deducted from the child's age. That's one thing that needs to be there. So if they are 18 and the I-140 is pending for 1 year, guess what? Their age is only 17. So then be watchful of all these things, be careful of these things. If you miss one little thing, one little date, your kid may get kicked out of this application. So please be careful on those things, and if required, have a legal assistance on that and contact a competent immigration lawyer.
Yeah, so how do you kind of track this to make these calculations? Ultimately, what you want to do is figure out how long your I-140 has been pending. To make it easy, let's say the I-140 has been pending for 365 days, 1 full year. That means that the final action date must become current before the child turns 22, not 21. So that date, you need to look up in your calendar, what date do they turn 22, and monitor the final action date every month up until that point. If they go beyond 22 and your final action date is not yet current, then you're in trouble. So that's kind of how you monitor it, is you figure out how much time your I-140 grants you, the amount of time it was pending, add that to the child's age when they're 21, and by that date, that's when you need to make sure your final action date is actually current.
For the quick review, guys, there is filing dates and final action date. When you go to the visa bulletin, though, there will be filing dates, and this is called final action date. You know it, and you know where to look, EB2 or EB3, depending on, or EB1, whichever category you are in. Please look into the final action dates for the purpose of this one, not the filing dates. Don't go to the USCIS website and look into when we can file. That has nothing to do with this one. It has only to do with the Department of State visa bulletin, only the final action date. The filing date does not save your kid. It's the final action date that will save your kid.
All right, I think we've covered it as best we can. It's a very messy topic, hard to really keep track of all the different dates and timelines. But if you have questions about how this actually impacts your personal situation, you can always set up a consultation with us or any of our attorneys here at Reddy Neumann by going to rnlawgroup.com.
Thank you very much.